Welcome to Law Pulse YouTube channel, Administrative Law, Theory of Separation of Powers. Today, let us discuss about the theory of separation of powers, the position in India, United Kingdom, and USA. So basically, first of all, we should have to know what is the separation of power. What does it defines? Rather, the theory of separation of powers was propounded by Montesquieu in his book Spirit of Laws during 1748. As such, it emphasizes the three organs of the government, that is legislature, executive, and judiciary, should function independently and should not encroach upon each other's domain. The objective of this separation of powers, according to Montesquieu, is prevent concentration of power, safeguard the liberty. If all the three organs of the government concentrates with one person, it leads to anarchy and it leads to despotic attitude and the dictatorial type of government as such. For that reason, the Montesquieu, they think, have said the three organs of the government, that is legislature, government, executive, and judiciary, should function separately. So then the meaning of the separation of powers, what do you mean by this? Legislature, executive, and judiciary. What are the actions and the character of these three organs? Legislature is nothing but the elected body makes laws which are required for a civilized state. And executive is nothing but it is an agency which enforces the laws made by the legislature, and this is called as executive. Whereas the judiciary, it interprets the laws which are passed by the legislature as such. So, pure theory demands mutual exclusiveness of the powers. Already, I told you that the separation of powers, if it concentrates in with one person, it leads to the anarchic rule. For that reason, the jurist says that there should be a mutual exclusiveness of the powers purely. And in practice, the complete separation is neither possible nor desirable. So hence, the different countries adopt the modified versions. So coming to the countries, rather, the United States of America, where what is the position of the separation of powers in America? Let us see here. The US Constitution strictly follows the Montesquieu model. The Montesquieu model is nothing but the Article 1 vests legislature powers in Congress. Here, the Congress is nothing but the elected body of the Parliament of the America. The Article 2, which says the vests executive powers in the President, and Article 3 vests judicial power in Supreme Court and lower courts. The key features, according to the separation of powers, the position in USA are checks and balances. Each organ controls and balances the other. The example is presidential veto and judicial review, the impeachment of president. And again, the judicial review established by Marbury versus Madison case. Rather, this was pronounced by the Supreme Court of America during 1803. Thus, the US adopts strict separation but mutual checks. So, in total, we can say in USA, the judiciary, executive, and legislature strictly works according to the principles of the separation of powers. Then coming to the positions in United Kingdom. So United Kingdom does not follow the strict separation due to its parliamentary form of government. Rather, there the United Kingdom is based on the legislature, where the parliament is the supreme there, and even the constitution of United Kingdom is unwritten, rather, whereas the unwritten laws also plays a vital role in United Kingdom. The prime minister and the ministers are the part of the legislature, the parliament, and the executive, the government. Judiciary, however, it is comparatively independent after the Constitutional Reforms Act of 2005, where the separation of House of Lords by the judicial functions. Earlier, the House of Lords is nothing but it is the upper house of the United Kingdom Parliament, where the thinkers and the juries and the members of the elected members were constituted the House of Lords. The House of Lords is the apex, the judicial appeal body, judicial organ apex body, where the House of Lords decision used to consider as the final order or verdict. Whereas during 2005, it has been amended that the separation of House of Lords from the judicial function. Then UK follows the separation of functions rather than the strict separation of powers. Example, David Dicey emphasizes the parliamentary sovereignty over separation. So this is the position of separation of powers in United Kingdom. Yes, coming to the position of separation of powers in India. So how the separation of powers, that is executive, legislature, and judiciary, works, functions under Indian Constitution. Rather, the Indian Constitution does not provide for absolute separation, but it ensures the functional separation with the checks and balances. The legislature, that is, the parliament, makes laws, Article 79 to 122. The executive, the president and council of ministers execute the laws under Article 52 to 78. Judiciary, the Supreme Courts and High Courts and subordinate courts exercises judicial powers under Article 124 to 147. So these are the positions of the separation of powers in USA, UK, as well as in India. Now, let us discuss further about the examples of overlapping where it is. The executive is the president, we say, is the part of the legislature as such. The legislature exercises judicial functions also. For example, the impeachment of president and removal of judges. So that is vested with the parliament with the two-third majority, and the parliament have that power to remove or to impeach either the president or the high court or supreme court judge as such in India. Judiciary can strike down the unconstitutional laws. For example, when the Keshwanand Bharti case came up before the Supreme Court during 1973 relating to the property dispute of Ednirmat of Kerala, there the Supreme Court, the constitutional bench said the basic structure doctrine, and it underlines the basic structure of the constitution cannot be amended or cannot be changed unless it warrants whatever it is. Hence, India follows the separation of functions with checks and balances, but not the strict separation as such. Then, the case laws relating to this the separation of powers, very importantly, under this topic, the separation of powers, are Indira Nehru Gandhi versus Rajnarain during 1975. This is very significant case appears in the law, the legality under the constitution, where the then Prime Minister passes an amendment with regard to that either the Speaker of the House, the Speaker of the Lok Sabha, and the Prime Ministers, their elections cannot be questioned by any court as such. This was struck down by the Allahabad High Court, and it was a landmark judgment during 1935. That was a writ petition filed by Rajnarain, and on behalf of Rajnarain, the great jurist of India, Shanti Bhushan, argued on behalf of Rajnarain as such. And the Keshwanand Bharti versus State of Kerala also underlines the judicial review ensures the balance of powers. And in another case, Ram Jovaya versus State of Punjab, that was pronounced by Supreme Court during 1955, the Indian Constitution does not strictly separate powers but recognizes the functional separation as such. Then let us conclude about this subject, the separation of the powers under the administrative law. So in USA, there is a strict separation and checks and balances. That means to say executive functions separately, judiciary functions separately, as well as legislature functions separately under USA. Whereas in United Kingdom, this is nothing but the fusion of powers. Parliament is supreme here. Parliament has the sovereignty. Whereas in India, the separation of functions, the checks and balances with judicial supremacy under basic structure of doctrine. The separation of powers is essential for democracy, but its practical application varies according to the constitutional design.